From Springfield, Illinois, high atop the IAR Plaza. Probably used that one too many times. At any rate, we're 4 stories up, looking at the Governor's Mansion and the Capitol on this fine overcast morning. Thanks for joining us. A couple of housekeeping items before we go. One is phones, please. This is a phone meeting, though, so you need your phone to hear us. But please mute your phone. And also, if you have a camera on your computer, please turn that function off. It would be awesome to see all your smiling faces, but it's easier for our display if the cameras are disabled. Second item of business, and we always get the question, so we're presenting the question with the answer. Is it possible for me to get a copy of the slides? The answer to that question is no, not slides only. Our options are only or audio plus slides. The slides and audio only will be available within the next 48 hours, give or take. Mr. Ralph, our tech guy who helps us out so much, and we always want to thank him for that. We received many questions on this particular subject, so we are handling one that we received in the order of receipt to the extent possible. Don't recognize your question exactly as it was sent. We did rephrase for purposes of slides and explanation. So hopefully we got the gist of your question, and if we didn't, please let us know if you're on with us today. We'll be proceeding at a fairly quick pace in order to cover all of the subjects. We think a little nerve here with these 2 subjects, and so they're great, but we have a lot of information for you, and we sure do appreciate your questions. So thank you for sending those and continue to do so. There were a couple that made it in after the slide, so fear not. It may still be answered if it was in before 9:30 this morning. So without further ado, my colleague Jeff Baker is here with me this morning. I'm Sierra Vance. I've done your legal hotline for a little while, and Jeff does our transaction helpline here. We've both been very busy, so we thank you for that as well. We are going to discuss fair housing topics due to the fact that it is Fair Housing Month. It just happened here. Meeting info. Okay.
Ted Bertrand is sharing his computer.
Ted. Sorry to call you out, buddy. We need to get.
Yeah.
Can I hit a tab?
Thorne, wait a minute.
Us here, guys. Thank goodness Ralph is in the room. I'd be screaming from the room right now. I'm going to carry on, though. Yes, sure. Okay, I'm going to proceed. Our overview, we're going to give you a couple news items to discuss in general and some specific questions and we are going to discuss some rental and property management issues. Thank you, Ralph. And one page. Awesome. Also, some questions that came in were completely unrelated to fair housing and rentals or property management, which is quite all right. We're going to try to get to those as well. Here we go. In the This Just In News category, on March 21st, 2015, some of you who operate in the unincorporated areas of Cook County may be aware of a new requirement before property is sold. This is the Cook County Zoning Use Certificate Ordinance. It applies in unincorporated Cook County, effective March 21st, 2015. Why the weird date? 60 days after January 21st, 2015, when the amendment was approved. The fathers and mothers. it applies in unincorporated Cook County, and what is it? Well, there's a fee, of course. The seller would pay $100 as a fee, and the seller would complete an application for a zoning use certificate from the county, a zoning administrator. The individual seller, when the property goes under contract, pays his fee, and he completes the form. It's a one-page form. I believe we have it available on our website. If not, county offices
What was his
have it
approach about?
available, I believe, online. The seller fills out the form. There's the property description, of course, the name of the person to contact. Then at the bottom, there are a series of questions that need to be asked. Once those are answered and the application filed,
So,
I
you know,
believe
by
within
virtue
10 days, the zoning
at that-
administrator gets back to the seller, issuing a zoning use certificate or denying the zoning use certificate. If denied, the administrator states the reasons and may or may not need to be cured depending on the situation in your transaction and pending probably not the case. Many times the buyer will care that the property be suitable for the buyer's intended use. For members, what are our suggestions? Be aware this zoning use certificate is in effect and that it's out there and required. The definition of seller does include seller's agent, which us, as we read it, implies legal agent as opposed to seller's sales agent or broker. So guidance for you is that you, in your capacity as a sales broker or property manager, perhaps helping in the sale of a rental property, do complete that form. The seller is responsible for completing the form. If the seller wants his legal agent, that would be power of attorney, otherwise known as an attorney in fact, or is at law to complete on his behalf. That's up to him or her. But at any rate, our guidance for our members is to complete the form. Reason being, there are some representations being made in the form when you answer the questions near the bottom are being made about the condition of the property. And answer them, you're probably on the hook for answers to those questions. So if the seller has questions about how he answers those, direct them to his attorney at law for some advice and assistance, and they can review the facts of the situation and determine how to accurately answer those questions. I'm joined by my friend and colleague Jeff Baker to tell you about a case we recently read about involving the Seller Disclosure Act.
Thank you. Like Betsy just said, this case just came out of the 5th District. Opinion was just written by the court there on the Real Property Disclosure Act. It kind of shakes things up, which is why we're putting in the just in section. It kind of changes, or potentially changes, our view of the exemptions to the Act. Let me hit some of the facts real quick of the case. The plaintiff in this case, Hawkins, served as the trustee of her own revocable trust, which was the title owner of Hawkins' home. The trust entered into a contract with an auction company to sell the home, and auction was held, and a buyer entered into a contract to purchase the home, but reneged when they weren't provided a residential real property disclosure report. Ended up suing the auction company for failing to provide the report, essentially blaming the auction company for the sale falling through. The issue in the case, whether the trust was exempt from coverage under the Real Property Disclosure Act and thus didn't need to provide the form. And then another issue was whether the auction company even had a duty to provide the report to the trust seller.
I'm with you.
The thing that got Betsy's and my attention on this case was whether or not up on the issue of whether or not the trust seller was exempt or not. The question for us was whether or not the auction company even had a duty to provide the form in the first place. We thought that was a threshold question. The court gave it very little attention. It appears that the parties maybe just conceded the issue. The important note that we want all of you to take away from on this particular issue is that it's going to be the agreement between the seller and the auction company, or the seller and the broker, as to whether or not any duty existed there. Otherwise, absent some contractual provision, there is no statutory duty for the broker / the auction company to provide that form. Whether or not seller is required by the form or not is a separate and distinct question. Couple bullets, but I just wanted to drive home that point that there is no duty unless a contract creates that duty. The other big takeaway is, like I said in those next few bullets, the redemption in the Disclosure Act forced by a fiduciary. It's a 15.3 if you're looking at the Act, by a fiduciary in the course of the administration of a decedent's estate, guardianship, conservatorship, or trust. We've seen I've did this provision numerous times on how to read it, how to interpret it. The general consensus has always been, and just to err, maybe it's erring on the side of caution, but that it's the fiduciary in the course of the administration of a decedent's, and then it's estate, decedent's guardianship, decedent's trust. Third, you're probably dealing with someone who's recently passed away and you're administering their final affairs. It's not been our understanding that it applies generally to any transfer by a fiduciary, regardless of the circumstance. The 5th District basically disagreed with our consensus and said no, it applies anytime there's a fiduciary transfer, essentially. So the transfer real estate, well, fiduciary acting in their fiduciary capacity, and therefore it's exempt. That's different than how we've always understood that provision to apply. That's why it could make waves later if this opinion has any precedential value and is applied elsewhere. That could change things, and so you guys need to know, need to be aware of that.
And what's even weirder about it is that the beneficial interest owner and the trustee were one and the same.
We're one and the same, yeah.
So and beneficial interest owner is included in the definition of seller, and those are legal arguments for us to have later, but be aware of the case.
Exactly.
Yes, and now moving out of the news category and into the fair housing category, I'm sure every person that has been a real estate broker for at least a year has some awareness that April is Fair Housing Month. Also, it's just so important to have, when you're in real estate brokerage, have a basic knowledge of the fair housing laws at the 3 different levels. There's the federal laws, there are various laws that apply that deal with fair housing. The state law, it's the Illinois Human Rights Act. And local law ordinances are oftentimes there depending on where you live, you work. Many are stricter than federal or state. And what I mean by that is you will find that there are more protected classes at the local level. Is it 5 or 7? Can't even remember. Maybe 7. State has more, and local ordinances oftentimes add on protected classes. So generally be aware of that. It's a case out there that, even if you're aware in your own area, if you're dealing with properties that are located in another area, but you do need to be aware. We had a broker from the Rockford area dinged because wasn't aware as she was dealing a property in the city of Chicago that source of income was a protected class and ended up in trouble for that. It's just an example of why you, as a broker, need to be aware of what's going on where you're located. I'm going to review general concepts with regard to rentals and sales transactions in the application of fair housing, and then we have, I think, 2 questions that came in advance of the webinar that we'll deal with as well. One, and this is a rehash, but it doesn't hurt to review. It's important to treat all prospects according to the same process. You have a process in place that's full of procedure that uses standards for assessing whether or not a person is qualified to either rent or purchase. it's important to display the fair housing posters and to commit to the principles of fair housing. As a side note, I would give you, I guess, for lack of a better term, that NAR has, in recognition of Fair Housing Month, a page that contains a new poster. So if you're looking at your office and your old poster is drab and worn and dog ear, there's a new one out there that's pretty cool. And there's also the proclamation you can download and some sort of public relations on that. So there are resources out there for you to recognize Fair Housing Month. There are suggestions, have a contest, poster contest, some such thing. Another is it's important to advertise in media of general circulation. If you too targeted, too niche, if that's even a word, that you're not focused on the exclusion of another. So where you hear things about preferences or limitations on those that are members of protected classes. In caveat is try to avoid preferences, avoid limitations on protected classes. The whole key question in a fair housing case is going to be, was housing to have a protected class? Directly or indirectly, was housing denied? Preferences are a little fuzzier, and I'll get into that a little more in a couple minutes, but just of those possible issues. Remember permissible grounds for denial or for different treatment. By different treatment, I mean maybe a higher security deposit or a higher rent or something of that nature. Number one, ability. The ability to pay the rent or the sales price. Approval to handle the obligation. And not source of income, because many places, not at the overall state level, but in pockets within Illinois, source of income is a protected class. So if, for example, your source of income is a second or a housing choice voucher, you have the financial ability to meet your rent obligation. Your income might be different than traditional employment. For rentals, these are some of the permissible grounds for denial or different treatment. Criminal record. Criminals so far are not a protected class under federal, state, and I'm not aware of any local. Street. If a prospective landlord or property manager calls prior landlords and gets a bad report, too much damage, many criminal friends visiting, things of nature, bad tenant history, municipal grounds for denial. Times a low credit score can be for denial. Just I ask you to keep in mind that sometimes folks are well-qualified financially but have no credit score. So those are just some of the more common permissible grounds for denial or times different treatment. But I want to bring you up to date as much as we can on a case that we're watching. It started with federal rules. Federal rules in 2013. We talked about a HUD rule that and said strictly prohibited impact or discriminatory effect. And what I mean by this is the rule or the requirement or whatever was in place, and this comes up a lot in lending rules in our area of operation, but prohibition or qualification was not on its face discriminatory, but on the other side of things, there was a discriminatory effect. In other words, people in a protected class were more affected than others that weren't in a protected class. Qualified or codified what was being found in cases in this rule. Well, now, there's a case that has gone all the way up to the U.S. Supreme Court, and I'll give you the caption of the case there in case you are following it or put it on your radar. The Texas Department of Housing and Community Affairs Inclusive Communities Project. So it comes out of Texas. The case has been briefed and argued in front of the U.S. Supreme Court January 21st, 2015. So now we are awaiting the U.S. Supreme Court decision on whether or not the HUD rule impact will stand. So on this one, just want you to be aware of the cases there. Stay tuned. We will report as soon as there's an opinion. What does the rule presently say? What am I even talking about, just so you're aware? The rule presently states that a legal sufficient justification in order for a requirement or rule to have a discriminatory effect. So if you have a rule on its face, or a prohibition or a requirement or qualification that on its face is not that must be necessary to achieve a legitimate non-discriminatory interest, and there's going to be no less discriminatory way to do it, and that end word is important, and then that has to all be supported by evidence, which are our favorite in the legal world, fact questions. The law can say, but there always has to be a set of facts to apply, and those facts have to show, look, it's not discriminatory on its face. There was, unfortunately, a discriminatory effect, but there's no better way to do it, to achieve the legitimate means to end, if that makes sense. So they state it's being challenged in that Texas case. G is to address some member questions that came in the nature of fair housing. Yes, with the beginning, and if you joined us late, perhaps please mute your phone lines if you haven't done so already. Thank you.
Member questions on fair housing topic, and we're going to try to get as many of those as we can. And I think we'll just kind of hit these fairly briefly. But some very basic. Is it true you can't discriminate based on race? Yes. No race discrimination. There's a question of what's the difference between race and color. Color is just a subset of race. It describes skin color only, whereas race is a more complete set of characteristics. That's it. On the different areas of what control this. Illinois Human Rights Act is where you categorize for Illinois state law, and it's also where you find exemptions for those circumstances where, I hate to say where discrimination is allowed, but perhaps that's saying it. But so to give you a couple of quick examples of exemptions under the Illinois Human Rights Act. Owner of a single-family home. Some lists on that. That owner can't own more than 3 properties. The owner has to be the last current residence. Cannot be using a broker and can't be publishing ads. Occupant buildings with no more than 4 units. The stations have an exemption, but again, just like the owner-occupied, all of these have their own. While given an exemption, they have their own limits. So it's not enough to just say you're a religious organization, therefore you're exempt. The limits on those: race, color, national origin can't be the basis of discrimination. Qualified housing for seniors also has an exemption. There are numerous, Betsy, I don't know if you know off the top of your head how many there are, but there's more exemptions. Those are just some of the bigger popular ones.
Right. You mentioned that no discrimination on race. Did you say that? Yeah, I just missed that because I was...
Right. Under no circumstances is race allowed to be the basis of discrimination, period.
You did say that.
Yes. So like I said, those are just a few of the exemptions. It's not an exhaustive list. Go to the Act for an exhaustive list. But like I said, even if you do have an exemption, you have to be very careful because the exemptions have exemption from the exemptions rules on them to when they apply.
Easy to read, exemptions from exemptions.
They're very narrow exemptions, I guess, is the way of saying it.
Right.
So,
And if you're working with an owner that has a question, if you're working with an owner, then he can't discriminate because you're working with them. And it was something Jeff said earlier. So as an example of that exemption works, it doesn't if the owner of a single family is using your services. And so the no published ads, in essence, he's going to have to do it on his own by word of mouth.
mm-hmm.
That's the way he can take advantage, if you will, of exemption. Moving from fair housing, we did that really quickly because we have a whole bunch of stuff on rentals and property management, and we did quite a few questions in on that subject. General overview. I probably said it till I'm blue in the face, but I think there is still some level of misunderstanding out there and probably will continue to be forever. The Real Estate License Act does cover leasing for another and for compensation. To the extent that a person doing anything on Section 1-10, definition of broker, for another and for compensation that involves leasing, show rent, collecting rents, holding security deposits, helping negotiate leases, things of that nature, that person needs a license to do it. And here's the kicker, the same Illinois Real Estate License Act and the same definition of broker with all the licensed activities covers sales. Then you go to the provision in the Act that says under 10-20A that a licensee can only do those licensed activities for one sponsoring broker at any one time. So for those folks that are sponsored by ABC Realty Company, they might have a little property management company on the side. I'm doing air quotes, you can't see me. Problematic. That licensee is the 100% owner of properties being managed. Owns it himself or herself, is 100% owner in the corp that the owner of the property is being managed, LLC or whatever the entity is. You got to be the 100% owner of that. Or you can own it jointly with a spouse. That still counts. But if it is a separate entity that owns the properties and doing management that includes licensed activities for compensation, that has to be done through your broker over here. I'm using my hands that you can't see, at ABC Inc. under sponsorship. So the managing broker at ABC has to be cool with the property management business that's going on under particular ABC shingle in our example. Also, for all of that to go through the sponsoring brokerage like anything else. And like when questions in, what I'm going to try to do is assess the member, or address the member questions. Jeff, maybe you could look at the ones in the chat box. I'm going to move on, and then before we break, we can see if we can deal with those. Okay. With rentals and property management, with regard to agency disclosures, who's your client? That's one of my favorite questions in the world. If you are a property manager, typically you will represent the owner or the landlord. Does the landlord or the owner want you to represent the tenant? If so, if you were in that situation, you're a dual agent. If you're designated agent / property manager for the landlord, and then you would also representing the tenant, that's dual agency. That requires the full-blown agency disclosure. Wasn't always the case, but is the case presently. If you're a property manager, your landlord's going to want you to represent him only. There will be dual agency allowed, and the tenant will be represented by someone else. If the tenant is not represented, then it would be a customer of yours. You want to make sure you notice of no agency. if you're giving notice of no agency in your application for rent, make sure that's right up front. Because the tenant's going to be saying, I understand I'm not your client, and I'm going to be telling you a whole bunch of confidential information, and you're going to use it for the benefit of the landlord. Which makes sense, nevertheless required. D applies the leasing agent licenses. The leasing license is a lesser included of licenses. There's the managing broker license now, there's the broker license, and then there's a leasing agent license. Agent is a limited license. You can only do residential leasing activities under it. However, it does have to be a license sponsored by a sponsoring broker, and having a managing broker who's the human in charge of you. And you do all your work through a sponsoring broker on Section 10-20A. You're paid by that sponsoring broker. So we had a member question come in. There were leasing agent licenses and managing a building, but not sure they were sponsored by any brokerage company. They just went out and got their leasing agent licenses. Wasn't quite clear on the facts of the situation, so I'm going to answer both situations. If folks that got their leasing agent licenses were truly regular employees of one property owner, you would need those licenses to manage the own at one owner. So you would want to look at Section 5-20, subparagraph 1, which is the owner exemption, which includes regular employees. So you have to be a regular employee under the IRS definition. So you got to work at least 20 hours and be a legit regular employee. You can't work 2 hours a week. And regular employee exemption. And if these folks are working for more than one owner, then they do need at least leasing agent licenses if the only activities they're doing are leasing activities. And they be sponsored by our friend over here, ABC Realty, like it's me, ABC Realty Company with a managing broker in charge of you. They, I think you get this right, that I'm just babbling. Yeah. Okay, and the common question that our person online, what if the agent is the owner exempt? And I think I answered that question.
Right, 100% owner if they're managing property or 100% owner of.
Right, but they're licensed, so they have to give disclosure that they're a licensee, and they couldn't be a dual agent in any transaction.
Just real quick, because I think we can answer this very quickly. The question that we got is with regard to property agreements, whether or not there's a template. No, there is no template. There are no forms. As one who answers the transaction questions, what I can tell you, and someone in private practice writes these agreements, what I can do is you do not want to use a form. A property owner should never want to use a form for that kind of agreement. That needs to be customized. It needs to be tailored to the type of property, type of management that's taking place, all the rights and obligations of the parties involved. Under no circumstances would I advise a client to use a form for that kind of agreement. That's why one does not exist.
Right. I think we can do two. I'm sorry.
No, it's fine.
Okay. A broker who owns 100% of a rental property does not have to run rental through their agency, correct? That's a follow-up to what I just said, but keep in mind, 100% owner. And then the next question, or the next statement, I thought leasing and not property management. Well, property management's a fuzzy phrase because what is it? What the leasing agent can do is those licensed activities, those things that are enumerated under the definition of broker with regard to residential leasing. So residential leasing units, they can be involved in rent collection as long as it's running through their sponsoring brokerage company. And they take security deposit back to sponsoring broker as long as it all deals with residential leasing activities. They can't do is make sales referrals to sort of distinguish. So I don't quite know how property management's being used, and that's part of probably our. understandings. Jeff, take it away.
More rental questions that we received in. What do you recommend to make sure the landlord stays current on the mortgage? Nothing. We don't have a recommendation.
The lawyers are speechless.
Right. Cross your fingers and say a prayer, I suppose. I think the question was asked in the context of, do you have an owner who doesn't pay their mortgage and then gets foreclosed on? All the tenant really has to fall back on at that point is a state law that protects tenants in foreclosure. They have rights. They get to live out the term of their lease. There are notice rights. That's really the extent of their protection, though. There's nothing a tenant can do to make sure their landlord is actually doing what they're supposed to be doing. So, right. Unfortunately, that is the short quick of it. So,
right.
Next slide.
Nope.
Question, and I think I used the exact words of the question. I'll go into a little bit more detail here. But in the question, it was, in a lease option, the option fee is generally non-refundable. If the property goes into foreclosure, can the tenant get out of the lease and a refund of the option fee? All right, what we're assuming they're talking about here is a lease with the option to purchase. And just to clarify, the quote-unquote fee for that option is actually not, I don't like the word fee, it's consideration. It's paid for the option. The minute you pay for it, it becomes, that money becomes the property of the landlord slash seller. It's not a refundable item. A tenant in a foreclosure property, as I just said before, has rights under state law, but if you're worried about your rights with regard to the option that you paid for, that unfortunately is a private legal issue between the tenant slash purchaser and the landlord slash seller. And if the tenant slash purchaser of that option want to exercise their rights against the landlord for failure of the option or failure of the ability to exercise the option, that private right of action that the tenant will have to take up in court against the seller landlord on their own.
Okay, I was actually mentioned in order to drive the bus here. Number of questions. This one came in, are renters' rights different if they're renting a unit from a condo owner or management? So my parenthetical question, I guess, meaning the condo association or managers of the condo association or the owner. So basically, who's responsible to the owner as landlord? And the reason for questions in there is because I think I'm understanding the gist of the member's question, but not positive. So that's going to answer the question, who's responsible? Without X, the owner of the unit is the landlord and thus responsible to the tenant or the renter. Whether it's a tenant, whoever's in the property, will have to abide by all the rules of the condo association. So landlord charge subject to whatever the condo association requires of its unit owners and or renters. The section where an association actually acts the role of the landlord because they've taken over the unit due to non-paid assessments. So those situations occur, in case the association will be playing the role of landlord.
If it's been without heat for 5 days and is now wanting to deduct the 5 days of rent from the balance, is this stated in the city of Chicago? For Justice Chicago, but I guess I real quick should preface the answer with, if anywhere other than Chicago, you have almost no rights of stop. There's some, I suppose there are some rights in the act under state law, but you have to jump through many, many hoops to get it done. The question Chicago, as the answer says, their tenant's right to set off is somewhat limited. I put RLTO code section, and you want to go look at that. It's actually a fairly easy section to read. Be advised that it's fairly long. There are different circumstances. For instance, houses aren't provided. There's circumstances for permission. There's circumstances for set off. There's circumstances for finding other suitable housing. So you have to work your way through that code section to fully understand it. And the key here is that It cannot just set off on their own when they feel like they've been wronged. Most times, you are required to give notice to the landlord. Landlord is given most times a 14-day period to cure whatever defect it is. You must have that before you ever have a right to set off. There is one code section in subsection 110F that limited options for set off in the case of essential services like some utilities. However, and I've seen this happen in eviction court before, where a tenant believes they've been wronged, they stop on their own, and only to find out that now they're being liable for back rent and being evicted because they didn't follow all the rules. Our number one piece of advice, if you have a tenant feels wronged in this way and wants to set off, they need to consult an attorney before doing so. The obvious implication of off in the wrong circumstance, now you haven't paid your rent in full and now you're subject to eviction, no questions asked. So there are serious implications to doing that, which is we never recommend it unless an attorney is advising it.
Right, and I think our question was based in Chicago, and the landlord-tenant friendly ordinance is just stuff to answer that question.
And it is, generally speaking, that tenant-friendly ordinance is more tenant-friendly than the rest of the state with regard to set-off. However, it is not carte blanche for tenants to just your own rules and say, I was without heat, so I'm just not going to pay you for 5 days rent. No, you're short on rent. Now you are subject to eviction, and it's a very dangerous game to play, so you just need to tread very carefully.
Check with the landlord.
Yes.
First and foremost. More member questions, and we got a couple more questions in our chat box. What we're going to do at this point is get through the balance of the presentation and then go to those. I think we can deal with them, but let's through the prepared portion. Another question came in. Is it permissible to offer tenants referral fees for your properties? If so, how much? The license law answers the question. Section 5-20, subparagraph 10, there's a little exemption for tenants in a building or complex where the tenant lives that wouldn't have to have a license to refer no 3 other tenants per 12-month period to that particular building or complex, no than $50 or 1 month's rent, whichever is less in a 12-month period. It applies to referrals only. It does not allow this unlicensed tenant to other licenses, the most obvious one being showing other units. They might go over and hang out at your unit as a licensed tenant, but that is the little there for referrals to unlicensed tenants in a building or complex. This came in. How does we're in your questions. I was going so quickly that I didn't realize our subject matter changed. This is a potpourri section, although I see some for property management and fair housing. How does the, in quotes, law address third-party websites where FSBOs and by-owner rentals are listed? To assess the license law, if they're only advertising outlets, they're going to be exempt under 5-20, subparagraph 9. I think you'll see 5-20 is the License Act that section contains the exemption. The paragraph 9, if outlet or the website or the newspaper or whatever we're talking about, the advertising medium, is simply providing space for a fee where no license activities are being performed, they would be exempt for that purpose only. However, if they're doing something else that would be a licensed activity under the Act, for example, referring, real business, lead generation, if they're a business, they need an Illinois brokerage license if they're doing this in the state of Illinois. And the place to complain, which are one of these questions out here, if somebody's doing licensed activity without a license, the place to complain is the Division of Real Estate within the Illinois Department of Financial and Professional Regulation. So there we go. Where, Jeff?
Yep.
franchise question.
Franchise.
This will open a can.
This was, we weren't entirely clear on what the question was asking, so we apologize if we didn't get it exactly right, but the setup was, does the License Act restrict an out-of-state business brokerage from franchises in Illinois? What we took away from the question was, okay, you have a business broker company out of state that you franchise itself and sell a franchise here in the state of Illinois. And the question is okay, if the Illinois franchisee in turn brokers the sale of a business, which includes the sale of real estate, you now have funds traveling back up to the franchisee and back to the franchisor. How the License Act implicated that is how we kind of understood the question. So break it down. The sale of the franchise to the franchisee does not implicate the License Act. That's a completely different question, and to us, I think has anything to do with the License Act, where it might be implicated when the Illinois business broker here operating here in Illinois is brokering the business, and first, the business broker has to be registered with the state. Depending on kind of structure the sale is taking on, if there's equities involved or securities involved, they may have to have a securities registration. The bigger question for this crowd is, if the brokerage of the sale, or if the sale structure includes the sale of real estate, that business broker need to have a real estate license. Answer, yes. And now, I don't want to get way too into the weeds on this, but let's just say real quick hypotheticals, and I'll talk really fast, so I apologize. But if the sale of the business is the sale of the whole business, not an asset sale, but the sale of the whole business, the sale of stocks, and that business owns real estate, then in that case, you're not brokering the sale of real estate, you're brokering the sale of the business. If brokering the sale on, like, say, an asset sale, or a company owns real estate and then a different company owns the company located on the real estate, now you're getting into actual real estate transactions, contracts for the sale of real estate. In that case, you do want a license to sell or to broker the real estate, part of the transaction. It's probably even more complicated than the question even seemed, but hopefully we got the gist of it in that answer. So.
Right. That one depends on the facts.
Yeah.
What are the facts, and what license or registration do you need? And it could be one of a few. Okay, I got this question. The questioner wanted it addressed on the webinar, so here you are, question asker. What's the story on coming soon listings? This one is kind of nebulous, not like property management, but just in the fact that when you're about property management, what are you talking about? Because if you're talking about just like, what the heck? And the reason I say that is because coming soon, what are you talking about? What do you mean? I've heard coming soon in a number of different contexts. And this might be an REO type deal where a broker will be getting a listing, but he doesn't have it yet. So asset manager says, you know what, put your hand up, coming soon. You have stop it. You have written authority to advertise property for sales. So you find out, at least under the License Act, what you need is written consent of the owner to advertise the property for sale or rent. So you've done that. So it's not exclusive, and that's the situation I just described. You have the owner consent to put a sign up. There's no exclusive listing at this point. There's no MLS jurisdiction. So it is what it is. You're advertising the properties for sale. It's non-exclusive. It's fair game for other brokers to try to get the listing at this point because it's not exclusive. But the other we've heard coming soon is in the context of, you've heard pocket listing, office exclusive, those sorts of things. The agreement is exclusive, but for whatever reason the seller wants it out of the MLS, then you need to check your MLS rules, because the MLS that you're a member of does have jurisdiction, and the MLS is probably going to need on file in the nature of a waiver the seller, a sort of disclosure that's given to the seller as to, you know, the MLS in our area is the market, to have market, and you're choosing for whatever reason not to be exposed to it. So the seller show why it's in his best interest out of the bigger market. Also, it has to be not for an illegal purpose. Discrimination is the most obvious one. It shouldn't be strictly for the broker's best interest, in other words, for him to get both sides of the commission. That is usually the most valid reason. It should be in the seller's best interest for an office exclusive pocket listing, or as some would refer to it as coming soon. If it's done legally, it can be done, however. I have to say that. Okay, I have a couple more questions, and then we will, I think, have time to get to their questions that came in.
The ones that didn't make it into slides, and I think we've kind of probably already answered some of these, but just in real quick, one of the questions was, what about an advertisement that basically advertised to quote-unquote Chicago employees? The question we had was, well, what constitutes a Chicago employee? Is that anyone who's in the city of Chicago, or does that actually mean an employee of the city of Chicago? Either way, what the point we want to drive home, and I know Betsy mentioned it earlier, is when you get into the world of preferences versus restrictions or limitations, if you express a preference, you may be implicitly also expressing an implied restriction. As Betty went into with the case that's still out there at the Supreme Court, we're waiting for a decision on disparate impact. That rule exists. Everyone is still subject to it, despite the fact that we may not know exactly what it means. The take home there is that even though your advertisement, or even though your statement, or even though your policy may not be discriminatory on its face, the impact of it may be discriminatory and may be improper. So, tread carefully before using that type of language in your advertisements, expressing preferences, just because you may be also expressing a impermissible restriction.
Okay. Finally, the question that came in after PowerPoint, but before the webinar. Managing broker he's a managing broker for a broker, but he's a 30% owner of an LLC that owns property. So this goes back to my prior example, and he, in his fact, says he's 100% manager of the LLC. Fine, but in this example, the LLC is a separate and distinct entity. It is not 100% owned by the broker / licensee. So it's a separate entity. He's a 30% owner in that LLC, managing broker of his real estate company. Real company needs to be the manager, LLC, and everything has to flow through the bridge company. You're doing it wearing your broker hat. A LLC wants to be managed by somebody else. I have to be an unlicensed person. One of the unlicensed owners could manage it and then just disclose that there's broker ownership. I think there's that question. Now we're going to go back to one that came in during the presentation itself, and so that is why we are just trying to take people in the order in which they arrive. Okay, are any of the following wrong reasons for refusing to rent to people? Unruly children.
I think you can actually combine.
Yeah, we're going to combine the unruly children, the age of children who are school age, attending school, younger children, and who's supervising those children. Children generally, to their familial status and to the extent that the property is not legally qualified housing for older persons, they be denied on that basis. They denied for other permissible reasons on that basis. With regard to the question about supervising the children when parents are working, that would be another agency. I think the question is going to be, DC, if that becomes an issue. But for purposes of the threshold rental questions, those questions are going to be, are they qualified to rent the property is for lease?
Just to follow up on the whole other agency, if your issue is that particularly has children of a certain age and you realize they're probably going to be left home alone and someone that you believe isn't old enough to be staying there watching them, then I believe you're getting a dangerous familial status area where you're basically saying, we don't like the age of your children, or we don't like the quantity of your children, or the fact that you have children. All combined circumstance of, I don't like the ages and the numbers all put together. That's a familial status classification. That is impermissible.
Right. So that takes care of the kids. The next part is property where they're currently living. Dangerous. It's just, there will be health department and it could contribute to a bad tenant reference from the prior landlord. But is there damage? Is there unhealthy conditions? Those are situations you need to address on a case-by-case basis. It's not necessarily predicted. I think it might roll into bad tenant history, and as long as it's not based on somebody's membership in a protected class, you argue, well, we didn't take them because the former landlord said the health department was out here every week. Yeah, but it's hard to say in every case. People for the size of the property, what are the guidelines? Those are going to be occupancy standards. You need to check. You can limit the number of occupants. The rule of thumb, generally, the standards that used to be known as BOCA standards, it would be 2 people per bedroom. That's a very big generalization, but they should not be too restrictive. If they're super restrictive, like 1 person per bedroom, that is going to be subject to challenge. Try to keep it smoke-free property. A smoker can smoke somewhere else, so you want to discriminate. But the property can be smoke-free. Pets can be pet-free. So that, even though if the animal is not a pet but a service animal, then he's not a pet. He gets with an otherwise qualified tenant. Section 8 and property, Section 8, but property wouldn't pass the Section 8 inspection. If property is located where Section 8 or housing choice voucher is then have to go through the inspection. It's going to be the question. But cannot deny on that basis alone, on the fact that it's an 8, and you can't say, well, too bad my property wouldn't pass the inspection. It's going to have to, if you have an otherwise qualified candidate, it'll have to go through the inspection if that is the successful candidate. And I think that's all of the categories. Yes? And we're in 31, and we promised not more than an hour, so we're going to thank you for your time. If you have further questions, you can contact me and or Jeff. And thank you for your attendance and your attention. And we will see you in June, where subject matter, June 25th, will be the RESPA, Truth in Lending, disclosure rules, and the new estimate, document, and closing disclosures. So, join that one. Thank you. Adios.